Devin Lucas. So I am a real estate attorney by background. I've been a real estate attorney for a little over 20 years. I'm also a real estate broker and a realtor. So I'm an agent here with Coldwell Banker. I'm not a Coldwell Banker attorney. I'm just an agent. So while I am an attorney, I'm not your attorney necessarily, which brings us back to our very important disclosure, which is obviously, like all legal things, we're going to do sort of a quick deep dive into some of these new laws. There's no possible way that we can give you expert legal advice or address every question. So a lot of the things that we're going to talk about here today are just to kind of have the knowledge, to be able to share with yourselves, with your clients, to be able to talk about it. But obviously, if your clients get into some tricky situations or they need legal advice, they're going to have to consult their own attorney, especially when you get into landlord-tenant stuff. It is really dot the I's, cross the T's kind of situation. And then we've got some cities that have local jurisdictions as well that we may or may not get into. So we're going to talk about some of the 2025 updates. Obviously, the price gouging, which we talked about a little bit in the meeting, we're going to get into. But then we're going to take a deep dive on some of these new for 2025 issues, which are obviously the screening fees. That's going to be by far the biggest game changer that there's been in a long time. And I think a lot of people don't realize this. It is already effective. It's been effective for the last several weeks. So as of January 1st, these new laws take effect. So we're going to talk about that. Some other lesser known options that we'll kind of get into, photos and enhanced security deposits. I know Debbie mentioned that at the last meeting. The photos is one aspect, but they actually did tinker with the law a little bit on what you can and cannot charge for deposits and deposit refunds. So we'll get into that. We've got some new laws on credit reporting. We've got some new things on what you cannot charge for. Some changes to the unlawful detainer process, which presumably none of you are involved in, but it's good to know and good to be able to tell your clients about, as well as some new rules for commercial, which is kind of interesting because commercial laws have always been different. Now they're going to start blending with some residential protections. We've got some changes into when you might need to change the locks. And then we were going to see if we can sneak in just some updates to the Tenant Protection Act, Costa Mesa rent control. Those aren't new for 2025. Those were new for 2024. We'll see if we can talk on those, but those are such a big deal that we might need to do a second workshop just on that. Okay, so why are we here? Well, we've got clients that are confused and angry. They call you a super agent. They expect you to have all the answers, be able to address every concern. But when in reality, sometimes we've got this situation where you might be just as confused and scared as they are and not fully understand what's going on. California is a deep blue state. As we all know, I like to say that in California, landlord-tenant, it is an absolute trap. All of the landlord-tenant laws, in case you haven't already figured it out, they run in favor of the tenant. They do not run in favor of the landlord, with some very limited exceptions. And these laws, like I said, are very dot the I's across the T's. You really have to pay attention. Otherwise, you're going to get yourself into trouble in California. And why is that? Because obviously we're a very deep blue state. We're very consumer friendly, consumer focused. Whatever your political views are, it's kind of irrelevant. It's just a fact that California is very much geared towards the tenant protections. And you need to know that, and your landlords need to know that, especially when we talk about some compliance with these new laws. So what we're going to do here today is hopefully make it so that you understand these new laws, that you feel comfortable, confident talking about them. You can kind of point your clients in the right direction. But as we said, if they ultimately need some advice, they might need to contact an attorney. So one of the first ones we have, but I did want to get into some of these new for 2025 issues. One of which is the screening fee, which is going to be a huge game changer. So if you thought the HUD thing was confusing, get ready. Then we're going to talk about some of these other things, tenant credit reporting, photos, security deposits, some of those other things talked about earlier. Okay, so fees. So buried within the fee revision is several other things. Obviously, the way you can do tenant screening fees is the first one that we'll talk about in a second. But just some of these other easier ones to get out of the way. Mandatory credit reporting disclosure. So you have to give them the credit report. So no longer, it used to be that if the tenant asked for it, you had to give it. Now you have to give it. So if you take someone's credit, and we'll talk about, yes, this does apply if you use Rent Spree or Zillow or something like that we'll get into. But if you get someone's credit report, you have to give it to them. You just have to, period. Within 7 days of receiving the report, whether they request it or not. Receipt, you got to give them a receipt. That should be pretty easy. Got to give them a receipt. Reusable screening reports. So we'll talk about this. Nothing really changes in here except how it might be applied. So I think it's like Zillow, Rent Spree, some of those. It's like, if someone applies, it's good for 30 days or something like that. So you as a landlord, you have to take that. I guess that is the change now. I think it said you used to be able to take, now you have to take it, and you cannot charge an extra fee for that. So if someone already has their Zillow screening report, you have to accept that. So that's it. And we'll talk about how that applies for the fee process. You cannot charge for that. You cannot charge them a viewing fee or a processing fee or something like that. Because if you're truly getting the report for free, even if you're paying staff or you've got a property management company or something like that that's doing it, you cannot charge a fee to view that free report that you're getting. No screening fees without available units. This is potentially a big change. I don't think this applies to very many mom and pop people, but it's going to apply to bigger landlords or property management companies. You can still have a wait list, but you cannot charge an application fee unless you actually have a unit available. So no longer can you say, oh yeah, fill out an application, pay the fee, we'll keep your document on file when one opens up. No, you cannot do that. That will be a violation from now on. So you have to have a unit actually available before you can charge them. So that's sort of a potential big change. So these are the two ways that you can charge a screening fee. B is the default. You can charge a screening fee all day long as you refund every single one that you collect. Kind of makes it a little futile to even charge it. But unless you have this sequential application process that we'll get into, you can still charge a fee, but you have to return it. So someone, you decide not to implement this procedure, we'll talk about in a second. Someone applies, they've got a 400 credit score. Their last landlord says how they had to evict them and they were running a meth lab in the property. And you decide you don't want to rent to them. You're giving them their deposit money back, right? Or their screening fee back in this case. Even though you rejected them for maybe credit or what you perceive as legitimate reasons, you're giving them the money back. The only way to be able to keep a deposit, or sorry, not a deposit, the only way to be able to keep a screening fee and not have to refund it is if you implement a very strict sequential protocol that's going to require a written criteria and it's going to require you to take them in order. So let's talk about this in a little more detail. So like I said, yes, you can charge the fee. So first of all, you have to have a written screening criteria provided to the applicant in writing along with the application. How many of your landlords have a written screening criteria? Zero, right? Oh, I see one hand.
So
excellent.
how do you do that?
So we'll talk about that because California has kind of wanted you to have this for a while. This might motivate you that are doing property management, that are doing leases, or certainly that are working with landlords to implement one. So the state basically wants you, if you want to be able to accept deposits and not have to give them screening fees and not have to give them back, they want you to have a written screening criteria. Now, this is sort of a trap in and of itself, right? Because there's a lot of things in California that you are not allowed to screen based on. We all know, obviously, you can't screen on race, religion, ethnic, sexual orientation, kind of some of the common sense ones. But California over the years has really evolved that. Criminal checks, for example. You basically cannot have a blanket prohibition against arrest or criminal history. You have to really, really drill down on maybe no criminal violations pertaining to housing, right? Or no, criminal violations pertaining to, I don't even know, because it's really, really, really a bit of a problem when you start talking about what you're going to put in criteria. The things that we know that you can screen for, you can do credit score, you can do income, both the amount of the income as well as the source, but you cannot discriminate on the source, right? If someone's a Section 8 tenant, if they're an exotic dancer, or performing some other service that they're getting paid for, you cannot discriminate against the source of income. But you can set a legitimate requirement, okay, I want the tenant to have 2 times the income, or 3 times the income. What about 4 or 5 times? Well, now someone might argue you're being discriminatory. Because if I'm saying you got to have 5 times the rent, and therefore now by de facto impact of that, or disparate impact, you're all of a sudden creating something that's being discriminatory, that's a problem. So a lot of landlords are kind of sticking to maybe a 2 or 3 times the rent, maybe a certain credit score, maybe some sort of verification of employment, maybe a verification of prior tenancy. There's a few low-hanging fruit that you can put into a screening criteria, but the rest of them are going to start to get into a gray area. And I think for that reason, a lot of landlords haven't wanted to put together a written screening criteria. But if they want to adhere to this new law, they're going to have to do that. So that's step number 1. You've got to have the written screening criteria. Step number 2 is that you've got to take completed applications in the order in which they were received. This is where it's going to get tricky. The first applicant who meets the landlord's established criteria has to be approved. So if you go forward with this process, this is the limited exception where you can essentially not have to return a screening fee, right? So applicant number one pays the $30, $40 screening fee, whatever it is. You've got a nice, well-written, established criteria that says you've got to have a 700 credit score and 2 times the monthly rent, right? Applicant number one, I take your fee, I take your application. You've only got a 600 credit score. Okay, boom, I can reject you. I do not have to give you your application fee back. I take now application number two. I run their credit, I do all that stuff. Again, 400 credit score, rejection, not going to take you. Do not have to give the money back. Applicant number three, I take your applicant, you've got an 800 credit score, and you've got the rent, and whatever else my criteria established, I have to take you. I have to. Because that's the law.
Yeah, but the moving time is different. For example, if the third one, the moving time 1 month later, but there's some possibility can move in a week.
So the question was about the moving time. So maybe the screening criteria, and I think that would be a fair thing, is must be able to move in within 30 days or something like that. So I think you'd have to deal with that within the screening criteria. But let me finish this and explain how it's not going to work to take multiple applicants. So the only way this works is a sequential order, right? You have to accept them and reject them one by one. You have to accept the first one that comes in. So this is the only way to do it. In any other instance, like if you're taking 10 applications at a time and you want to see maybe one's got better credit, maybe one's got more disposable income, maybe one can move in tomorrow and one can't move in till 2 months from now. If you want to do that, fine. You can take 10 applications at once, but you're refunding 9 application fees in that instance because you did not meet this established criteria of having to take them one by one. So a lot of landlords that just say, hey, everyone submit, we're going to look at all applications, you're going to end up writing a lot of refund checks if you kind of stick to that status quo. The only way to do it where you don't have to refund the money is going to be this one by one application process. Question?
Yeah. So
oh, sorry, to the back real quick.
This is when you're collecting fees, but let's say for me, like I always say, go use Rent-Spree or third-party service to do that. So I'm
Yes.
not, or the landlord's not.
Hold that question for 1 second because we will get to Rent-Spree and Zillow and all that stuff.
I have a question about your...
Oh, no, sorry, in the front.
Oh, okay. So if you take multiple applications but don't have them submit, like to Rent-Spree, say 5 applications, you look at all 5, or your landlord, property owner looks at all 5 and decides, well, I like this one best, and then that one next, and then that one next. So then you contact number 1 and you have them fill out Rent-Spree. If Rent-Spree comes back okay, and the property owner says, I'll take that one, you're okay, you're not violating anything?
Well, you're not violating anything. So the question was, can I basically take a bunch of applications without processing the fees, right, or charging them a fee?
Correct.
Yeah, you can do that. But the second anyone pays a fee, you have not adhered to this criteria, and you're going to be refunding any rejected fees in that case.
But if you only take 1 fee,
If you take 1 fee and you accept that applicant,
then you're okay.
No problem.
Even though you've had 5, you've
Yeah.
collected all 5.
but if you take that fee and then you run their credit and their credit comes back as 400 and you reject them, you're refunding them the fee in that case. Yeah.
So it's best to collect all the documents first before running their credit?
Well, that's one approach. I don't want to say what's best. I think everyone's going to figure out what they want to do, but that's certainly one way to circumvent having to write a bunch of refund checks, right?
Yeah.
If you want to take the applications without necessarily doing the credit and background check first and then do those one by one, it's certainly going to limit the number of refund checks you're going to write. But someone might look good in their application and say, oh, I've got great credit or whatever, and then you actually pay or have them pay the screening, and it turns out that their credit's not as great or there's something in the background check you don't like, you're going to be issuing them a refund check in that case.
Does the all the applicants get the criteria when they're?
Yeah, again, for that to work, the only way to not have to issue refund checks is you have to have a written criteria provided to them. So they have to physically get it. Not even good enough to have it on the website or within the Zillow listing or whatever. You've got to have some sort of PDF that you're giving them right along with the application.
Wait, so that was my question. So your rental criteria, where they have to meet these particular criteria, you have to send that to them along with the application?
Correct.
So if they are doing a rent spree or a Zillow application,
Let's talk about rent spree. One more question if it's not rent spree, because then we're going to get into that.
Yeah, not rent spree. So is that rule that you have to take the first qualified, that's just for refunding application fees, right? If you could choose any applicant regardless if you're refunding the application fees. Am I understanding?
Correct. Yeah. Yeah. So in that way, I think you can still do whatever you want. You still say, hey, I want to take 10 applications. I want to run 10 credits. We've had landlords that are crazy. They want to interview people. They want to phone, Zoom. We've had a landlord that wants to go to a tenant's current house and see how they live. As long as it's not discriminatory and violating other laws, you can still do that, but you're going to be refunding every single applicant that you don't accept in that situation. Okay, so how does this apply to rent spree, Zillow, things like that? Well, I don't charge a fee. I make them do the $39.99 rent spree application. It's going to be a bit of a gray area. So the law is very clear that we talked about a second ago. You can use these reusable screening reports. So I think this is my commentary, right? I think it's going to boil down to this. If you're forcing them to pay a third party, you're out of luck. You're going to refund that, right? So if I say, you apply for my rental, and by the way, you got to go onto Rent Spree and pay this application fee. I've never accepted a rental fee in my life, right? We use Rent Spree as well. You're 100% subject to this. You're out of luck. You caused them to pay that fee. It was part of your criteria. You're refunding the money. But in the situation where they already have that, you could be in luck. So you have a tenant who comes to you. They've already done the Zillow. They already applied somewhere else maybe and got rejected, or maybe they just did it to be proactive. And they truly come to you and say, hey, Mr. and Mrs. Landlord, I have a Zillow credits thing already done. I'm going to send you the link to that. And you look at the link and you decide, oh no, your credit's no good, I'm going to reject you. In that case, you don't have to refund the money because you didn't force them to incur anything. You didn't make them actually pay for the screening fee. So in that particular case, I think you're going to be fine. Now, are people going to blur the envelope on that and say, well, you must have a prepaid Zillow account or a prepaid rent spree in order to apply? I think the second you do that, you're toast, and you're going to be writing those refund checks. And there's probably going to be tenants out there that are then sending the same refund demand to 8 different landlords, and you might not ever know about it. And they're going to get 8 different refund checks back. But if you have a policy where you're mandating that they go and get it, and they're getting it for you, you're out of luck. It's just as if you were charging the fee yourself.
So it seems to me it would be wiser to maybe have them fill out and submit the car's application to rent, do that preliminary screening. If they look good, then ask them to apply the application.
I think that's one of many solutions, yeah, and that's someone that doesn't want to go through the rigmarole, doesn't want to have the application. I think that's what a lot of people are going to start doing, is saying, okay, hold off, don't bother doing a credit check yet. Let's just look at your application. Maybe I'll check your references. Maybe I'll check your job. You can do all those things without getting the credit check. So that's absolutely one way to go about it. So,
Have them run their own credit.
well, again, you're now forcing them to pay a fee. You're going to be refunding that fee if you reject them. So if
You accept the application, then have them run their own credit. If you think, okay, the application looks good, everything looks good, you say, okay, you can run your own credit.
sure.
Yeah.
And if you reject that applicant, you're writing them a refund check. Yeah. So that would definitely be a way to curtail it. Maybe now I'm only writing a handful.
If not good, then you can reject it.
You can reject them, but you can also write them a refund check.
But if your policy is that, can you say that, I can only accept credit score up for 700?
The only way that you're not writing refund checks to rejected applicants is if you follow this procedure. Written criteria, given to the tenant, applications considered one by one, you accept the first one that meets it. It's the only way you're not writing refund checks. Everyone else that you reject, you're going to write a refund check to. So yeah, what is the answer? I mean, yeah, as a couple of people mentioned, maybe that's the answer, right? Maybe let's not pay for the screening reports yet. Let's do a little due diligence first before we embark on that. But ultimately, if you get 2 or 3 people that you want to check their credit because you're having trouble deciding between 2 or 3 people, and you get 3 credit reports, you accept one, you're writing 2 refund checks.
What if you give them the option to just fill out the car application, or if they'd like to fill out rent-free and they choose to fill out rent-free instead?
Sure, if you reject them, you're writing them a refund check. We got the theme, right?
What's the law on returning the deposit, the refund check? How many days?
Oh, 7 days. 7 days. Yeah, or 30 from the accepted application. That's a good question. I had it here. 7 days. 7 days of tenant selection, or 30 days from the submission, whichever comes first. So if you reject them, you got to get it back to them within 30 days. If you're just kind of sitting on it, then you've got to get it back to them within 7 days in that instance. But if you're just sitting on them, then you've got to get it back to them within 30 days, whichever comes first. Any other questions about screening fees?
I just have a general question. I've got a client who does require a credit app prior to meeting and wants to do a Zoom or a FaceTime prior to leasing. And I'm wondering if that is appropriate.
Well, we have clients that do that, and there's no rule that says you can't do it, but if you're doing it to be discriminatory, you're in trouble, right? If you're doing it because, oh, I really want to see what race they are, or if they're of a certain, religion or something, then you're going to be in a lot of trouble.
And I have another question. They also created an addendum. It's literally a 49-point addendum that's created by an attorney that they want signed in addition to the car app. Is that something that we can, as agents?
Yeah, so a whole other conversation. I mean, we've got landlords who do that. They want their own addendum. They want their own house rules. We'll get into one of the new laws about what you can deduct in security deposits, which we really need to move on to. You can have all the addendum and all the house rules you want, but if it doesn't meet with California law, you're out of luck, and you're not going to be able to magically keep the deposit or something just because it was in your addendum. So just finalize on this. If you want to follow that procedure, you got to come up with a written criteria. You got to provide it. You got to do the sequential order. Obviously, maintain records, track your fee collection, because that 7-day or 30-day refund is pretty important. And good luck. I'll do some more questions after. I want to talk about just a couple more things. Commentary, obviously. Look, this I won't get on the soapbox here. We don't have time. But California, nice deep blue state, consumer friendly. California's been pushing this for a long time. You do have these horror stories about tenants that apply to 10, 15 places. They're paying $40 an application each time just to get rejected. You can see where it has been abused by some landlords and really has put some tenants in a bad spot, and like college applications, right? So you can kind of see the sympathy and the argument to shift the burden, but this is typical kind of California. It's now pushing this burden onto the landlord. They really want you to have that blind criteria. They really want you to just accept applicants as they come. They really don't want you to be digging into all of these nitpicky reasons to reject people, and they want you as the landlord to pay for that. All right, let's talk about some of these other things, and then we can do some Q&A at the end. Some of these are pretty easy. So credit reporting. So if you're a tenant and you want positive credit reporting, that's now required. So there is an exception, actually a pretty broad one. Landlords that own 15 or fewer units do not have to adhere to this. You can still voluntarily do it, but you do not have to. But if you own 15 or more units, if you're a giant apartment complex, if you're the Irvine Company, or something like that, you have to now, by law, report the positive tenant payment history, which kind of makes sense because it's letting tenants build up, good positive rental history for all the payments that they've been made. You can charge them a fee up to $10 per month if it's an actual fee. You can't just charge a processing fee or an admin fee, but if you're using some third-party company or if the credit reporting company charges you for that, you can pass that along. But if it's free to the credit reporting, you cannot. The tenants can opt out of that. And even smaller landlords can opt into it, right? If you want to offer that as a service, hey, tenant, even though I don't have to report your positive credit, I will. Maybe a tenant likes that, and maybe it's a benefit you can give to your tenant. So that's a new thing required for bigger landlords. Okay, let's talk about this. So some enhanced security deposit requirements. So this is Assembly Bill 2801. It's really kind of tightening the rules on security deposits, what you can keep for a refund, and it's requiring more documentation, which is photography. Now, we've always done, we manage a few properties, including our own, we've always taken before and after photos. My background is as a litigation attorney. I think the last case I ever tried before a jury was a landlord-tenant dispute, and I gotta tell you, nothing is as good in court as a before and after photo, right? That move in, move out form, stain on carpet, you know, whatever, that's fine. It's not as good as a photo. Photos are great. Look, here was the perfect carpet before they moved in. Here is the trashed carpet after they move out. So the law is now mandating that we do this. It actually comes effective a certain date, I don't even know, April, something like that. Just do it now. So if you're leasing a property, take photos. Take a bunch of photos of what the property looks like before and after. We've always even told tenants to do this, right? So both landlords and tenants, you should all be taking your own photos. But it is now legally required that the landlord do it. They got to take those photos, they got to keep them, right? So you got to have before and after photos. But it's also now required with a deduction. So if I'm going to deduct $500 for that dirty carpet or whatever it is, I have to not only send that typical letter within 21 days that hopefully we're all familiar with, but now I've actually got to send a before and after photo. So Mr. and Mrs. Tenant, you know, here's what the carpet looked like before you moved in. Here's what it looked like after you moved in. Therefore, I'm charging you $500. And by the way, pre-existing law already said you've got to send them a receipt for that. So here's the $500 receipt for the cleaning fee. So you've got to have the photos, the before and after. You've got to do before and after photos, period, even if you're not deducting. It's required now. But if you're going to take a deduction, has to have a photo. If you do a deduction with no photo, you're not getting that deduction. You are going to lose in court. They're going to come after you.
Can you use listing photos?
You can use listing photos, but it would behoove you to take some more probably detailed photos. You usually don't have, you know, close-ups of the toilet or something like that on a listing photo. But yeah, there's no rule that says how many you have to have. There's no rule that says the resolution or, you know, anything like that. But I think it would be prudent to take a lot of photos. And take photos, don't take videos. The rule is very clear about photo. We've had landlords in the past that are like, oh, I want to take a video. Videos don't play well in court. No judge wants to watch a video. They want to see the photos, right? Photos. And then you can put that easily in a letter, before and after photo. So a couple more things. If you peel back the onion on this, they've actually added, so this is now we're talking about what we can deduct for a security deposit. They've actually added the words reasonably necessary. They've peppered it into all of the language about deductions. Did that actually change what you can deduct for? Not really, but what they're doing here is they're setting you up for failure, right? What was reasonably necessary? It's putting a new question into the equation, right? What's reasonably necessary to bring the unit back to the inception of the tenancy, less ordinary wear and tear. So ordinary wear and tear has always been in this. They added a nice big bold heading to this whole deposit law, which is Civil Code 1950.5. This was always kind of the common sense approach to this, but they've literally put it in the law now. It's the intent of the legislature in enacting this measure to ensure that landlords do not subsidize improvements of their rental properties with former tenants' deposits. Because that was always the accusation, right? Oh, you're repainting on my dime, right? You're doing new carpet on my dime. You're essentially getting a remodel with my security deposit. That's always the accusation that gets made. So they've made very clear that that's what they want to avoid. They've added the reasonably necessary language. Then they've come up with a really big one about carpet cleaning. Now, this has sort of always been the law, but they've really put it now into the law in writing. So how many landlords out there have said, like, oh, I'm going to have a preset carpet cleaning fee, or I mandate professional carpet cleaning at the move out of tenancy? Super common thing. We've seen it a lot of leases. Never really been legal, but now it's definitely not legal. So the law has been said that you under no circumstances can mandate professional carpet cleaning or other services unless it's reasonably necessary to return the premise to the condition it was in at the inception of tenancy, exclusive of ordinary wear and tear. So nothing's really changed here, but they're really calling out the landlords that really insisted on that professional carpet cleaning. So I, as the tenant, just want to clean my own carpet. Maybe I'm going to even go rent one of those shampooers. I don't want to pay a carpet cleaning fee. I'm going to go do that on my own. The law is really doubling down now and saying you have to let tenants do that. Unless you can prove with photos that it was absolutely reasonably necessary, less wear and tear, you are not going to be able to charge for any sort of professional cleaning services. This applies to carpet cleaning and just regular old cleaning. Any questions?
Can I find a residential lease after sale?
Oh, yeah.
When a new owner wants to obligate the previous seller, that they have to have the carpets cleaned when they move out?
Well, so a residential lease after sale is just a lease, right? So if they take it on the day of close of escrow, they've got to return it to the same condition, less ordinary wear and tear at the end.
So they can't require the seller to clean the carpets when they leave?
Correct.
In the lease agreement?
Correct.
In the lease, RLAS?
Correct.
On a short-term rental, typically I charge $500 cleaning fee right up front.
No. Oh, short-term rental, you can absolutely do whatever you want. It's the Wild West with short-term. Yeah, under 30 days, you can do that. Airbnb has cleaning fees. You can charge a preset cleaning fee. You can absolutely do that. Less than 30 days.
So if the house is professionally cleaned and windows are professionally cleaned before moving, can landlord require that it should be the same on move out, professionally cleaned and both windows and the house?
No. They can require it look the exact same, less ordinary wear and tear, but they cannot mandate that it be professionally cleaned. So if the tenant just wants to get there with some Windex and do their own window cleaning, you have to let them.
So how come airline company, no matter how clean you give them the property, they still charge you and they can do this, but not?
Well, they can't do it, and they've been taken to court. I know Arnell Property Management, they actually had a Department of Justice criminal complaints against them many, many years ago, and had to end up settling with the DOJ because they had a pretty clear practice of just charging every tenant cleaning fees no matter what, and that's 100% not allowed.
Isn't it after 2-3 years you cannot get charged for cleaning of the car?
Well, again, you get into that ordinary wear and tear. So if someone's been living there for 3, 4, 5 years with a family, there's going to be an expectation that that carpet's been used. So no, you cannot just charge them for new carpet because that's not fair. And especially
Cleaning you cannot charge.
Um, yeah, again, there's no black and white here. Reasonably necessary, ordinary wear and tear. Those are two, very vague things that are going to get, argued over in court. And that's why you want to have your photos. Last question on that.
If it is already in a lease from, say, previous years, like they rented it 4 years ago and it was written into the lease at that time, does it still apply when they move out, or it can't apply?
No, cannot apply. Yeah. Okay, just a couple more quick ones. We'll get through this, and then I'll stay for some Q&A. Basically, a new rule says that you cannot charge for accepting checks. You cannot charge any sort of check processing fee or anything like that. You cannot charge for notices. I don't even know that landlords do this. I guess some have in their leases. Hey, if I have to serve a 3-day notice on you, I'm going to charge you for that. You can no longer do that. So if you have to serve a 3-day notice on a tenant, you're eating that fee. You cannot pass that fee along to a tenant. Same thing with check. If it costs you more to process a check, you're completely out of luck. Unlawful detainer answers, this won't necessarily impact anything you do, but it's important to know, this has really evolved. It used to be that tenants had 5 days, calendar days, to respond to an unlawful detainer, which is an eviction. So if you serve someone, classically you'd serve them on like a Wednesday, they'd have Thursday, Friday, Saturday, Sunday, Monday to respond to that lawsuit. That got abused so long ago, the legislature changed it to 5 business days, but now it's changed it to 10 business days. 10 business days is a lot. That's like 2 weeks. So if you serve someone with an eviction now, they've got 10 whole business days to respond to that eviction. So, this unlawful detainer eviction process is supposed to be nice and fast. It's supposed to expedite the process. Here we have just one more thing that's going to slow it down.
I'm sorry, on the previous slide, the one about check, so if
Uh-huh.
the tenant doesn't pay rent or the check is returned due to insufficient fund, you cannot charge them?
Oh, no, yeah, no, that's totally different. Yeah, if someone bounces the check, you can still definitely charge them for the bounce check fee. And you can serve them a 3-day notice and something, but you cannot charge to serve the notice. But what the check, it's designed for, hey, yeah, I'll take checks, but I'm going to charge you an extra $10 a month to accept a check. Can't do that. Same thing with cash, by the way. I actually had a big dispute one time where a landlord wanted to mandate electronic payment, and the tenant wanted to pay, by check or cash or something. You have to take any form of payment they want, and you can't charge extra for that.
Also, let us know regarding pet deposit. Is it reasonable? Is it collectible?
Questions about pet deposits. Let's get through these real quick because that's not new, but I'll answer that. Okay, commercial tenants. This may impact some of you. Commercial has always been its own ballgame. Residential has always had its own laws. Commercial has always had its own laws. This is now, a lot of the residential protections are now going to apply to small commercial tenancies. And the specific ones they've carved out at first are a micro enterprise, which they kind of define as someone of 5 or fewer employees, with some other criteria, a restaurant with fewer than 10 employees, or a nonprofit organization with fewer than 20. That's probably a lot of small businesses, right? So that could be a lot of dental offices, even a lot of restaurants that have less than 10 employees. They're now going to have an enormous amount of new protections now that they never had previously. So if any of your clients own commercial properties, you're probably not going to be dealing with the evictions or something anyway, but just know that the laws have changed. So they're going to have all those same protections when it comes to rental increases, renewals, notices, just a whole lot of things. Is going to apply to commercial tenancies. One of our last one, you have to change the locks if someone's a victim of domestic abuse. This used to be kind of in there, but it wasn't quite as clear. You as the landlord have to, within 24 hours, change the locks. So if someone comes to you and says, hey, I got a restraining order against my boyfriend, I want the locks changed, you have to do it within 24 hours. If you don't do it within 24 hours, they can do it, and then you have to reimburse them. This allows for wider documentation, a little bit of a gray area, forms from third parties. Obviously, if you have a police report or something like that, that's going to count. What if just my friend says, oh, her boyfriend is bullying her, I want you to change the locks? You're probably going to need to be safe and do that. Obviously, if you've got a physician or a doctor's note or something, don't want to get too much into the weeds to this. Obviously, if someone comes to you with a concern about domestic violence or being a victim of abuse, you need to take that seriously. You need to change the locks. Otherwise, they're going to be able to do it for you.
Or the tenant?
Sorry?
If tenant requests to change their lock, who's paying?
The landlord. Landlord has to pay for it.
Is this just if the guy's on the lease?
No. It actually becomes much more complicated if the person's on the lease. So this applies, period. So if someone says they've got a restraining order or something like that, you have to change the locks. Now, if they've got a restraining order against a co-tenant, you probably need to talk to an attorney or something at that point, because now you're risking changing the locks on a tenant, which you're not supposed to do. So it gets into a much dicier area where it's both of the tenants. In that case, again, you're going to be caught between a rock and a hard place. You're probably going to want to err on the side of caution, but that's something I would need to look into, or I'd probably defer on that one. Okay, we've covered a lot. Thank you very much. Thank you.